Autónoma de México. We have four young scholars as speakers from different parts of the world. Our first speaker is going to be Weian Tsai from Taiwan. And I'm going to read, Weian, your biographical note. Weian is an SJD candidate at Harvard Law School. A few years ago, I also did an SJD at Harvard Law School, and her research explores how democracies can build resilient information environments that withstand authoritarian interference. Her dissertation examines the history of media governance in Taiwan and the challenges it faces in the age of disinformation and propaganda. It proposes a media governance paradigm that safeguards democratic discussion and protects national security. Prior to Harvard, Weian served as a legal advisor to a minister without portfolio in Taiwan, where she worked on issues related to national security, communications, and social media policy, as well as judicial reform. Our second speaker is Rogero Rodoni. You're there, Rogero? Yes, I can see you. Who won a PhD in December 2020 with honors from the University of Turin, with a dissertation on the criminal matter in the relationship between legislative law and national, conventional, and European case law. And since April 1st, 2022, he has been a research fellow in constitutional law, working on a project, The Constitutional Principle of the Natural Judge in the Current Complexity of the National and Supranational System of Jurisdictional Guarantees. He has served as an adjunct professor of public law and constitutional justice at the University of Turin. Our third speaker will be Paulina Jabłonska. She's a PhD candidate at the Jagiellonian University in Krakow, Poland. In 2025, she was a visiting student at the European University Institute in Florence, and previously a guest researcher at the Max Planck Institute for Comparative Public and International Law in Heidelberg. Her research interests lie at the intersection of constitutional theory, constitutional practice, and social-political reality. And she's currently pursuing a PhD on the specificity of constitutional interpretation by national constitutional courts. She's also been studying the concept of unconstitutionality and the roots of democratic backsliding in Poland. Her recent fascination concerns a relationship between abortion laws, women's harms, and constitutional law. And last but not least, we have Zheng Hongzi, who is a PhD candidate in law at St. Catherine's College at the University of Cambridge under the Tunku Abdul Rahman Scholarship. He completed his BCL at the University of Oxford in July 2021 and was called to the bar in November 2022 as a Middle Temple scholar. His research focuses on judicial power, judicial studies, law and religion, the right to equality and non-discrimination, as well as a right to freedom of religion, particularly in the context of Malaysian jurisdiction. And we're honored to have as a discussant for the four presentations, Professor Maryse Amos, Professor of Human Rights Law in the Department of Law at Queen Mary University of London, as well as the Director of the Human Rights Law Center for the School of Law. And she's also a member and my colleague in the Executive Committee of the International Association of Constitutional Law. Thank you so much, Maryse, for your time. My name is Gonçalo de Almeida Ribeiro. I'm a professor of constitutional law at the Católica School of Law in Lisbon. I'm a former justice and vice president of the Constitutional Court of Portugal, and I am looking forward to this session. So each of you young scholars will have 15 minutes for your presentation. I'm going to be minimally liberal or tolerant, but not excessively so. So 15 minutes really means 15 minutes plus 2 or 3 minutes for you to complete a line of thought that you have started before the 15-minute mark. And then Maryse will have about 20 to 25 minutes for her comments. So we will start not with Rogério, but with Weian, because she has a scheduling conflict and she asked to be the first speaker. So Weian, the floor is all yours.
Thank you so much. And thank you for accommodating my teaching responsibility later. And when I asked for to go first, I didn't take into consideration of the daylight saving that's just started last week. So I do have to leave by the end of my presentation. I really apologize for this. But thank you for all of the organizers, especially the chair and the discussant and my fellow panelists. And again, thank you for accommodating me. My name is Wei An. I'm a doctoral candidate at Harvard Law School. This is a part of my dissertation project, which is more broadly on building a healthier information environment in the age of disinformation, focusing on studying the case of Taiwan. So this is a bit of it on militant democracy and constitutional normalcy. So first, I would like to explain a little bit of why I'm focusing on this very old concept that was brought up in the 1937 by German jurist Karl Lowenstein. This is because it has pretty much settled its debate after the Second World War. Some countries incorporate elements of it in their constitutions and other just reject the idea. But recently, I think there are new interests and new relevance of this concept, especially in the US academia. So this concept had long been rejected in the US academia. However, because of the new challenges like the January 6th incident, Capitol Hill, and also challenges of disinformation and propaganda, I found that there is new interest in it. Also, this concept has been constantly invoked in Taiwan. So after the current government in Taiwan stepped into office, it has encountered waves of national security law amendments. So starting in 2019, there were the amendments to the 5 national security laws. And also 2020, there was a new law, Anti-Infiltration Act. Also, more recently, 2022, there was a substantive amendment to national security law, adding the mechanism to protect national core technology. So amidst these waves of national security law amendments, of course, this is to respond to the increasing threat, ever existing, though increasing threat from China. The concept has been constantly invoked in Taiwan as a background or justification for all of its law amendments. So my research question for this paper is to ask, what does the concept of militant democracy offer in the context of national security threat? And does Taiwan really need this concept? And to set the table a little bit further, when we talked about national security threats of Taiwan, what do we mean by that? And we can imagine 2 roots of threats to democracy in Taiwan. And they are, and I'm citing Professor Tom Ginsberg and Aziz Hook. They propose there was 2 types of threat to democracy, and there are democratic collapse, that's an instant destroying of democratic order. So one can imagine Taiwan if being taken by force by China, this is an instant democratic collapse. And a more nuanced route, I would argue, is democratic erosion. So China has long sought to infiltrate political sceneries, institutions, and to influence public opinions in Taiwan. And we would say that this is if one day Taiwan is to voluntarily give up its democracy and to opt for unification, this is a gradual route to democratic erosion. Sorry. And to further set the table, I would like to argue how Taiwan is facing challenges in the digital age, in the area of disinformation and propaganda. So this is from existing literature review, and I will introduce it in terms of social media and also traditional media. In the field of social media, existing empirical research shows 3 things. The first thing is Taiwan is a target of sustained propaganda disinformation campaigns from China. So in my paper, I reviewed a lot of empirical research, and they've all found that from the attack side, there is sustained campaigns from China. And secondly, so as opposed to most Western research on disinformation and propaganda, they found that disinformation oftentimes just seek to find whatever divisive social issue there is and to build on that. However, in Taiwan, one thing that's different is it is one directional. That is, it's undermining the ruling Democratic Progressive Party that is more anti-China and pro-Taiwanese identity. So it's undermining one party and preferencing the other party that is more pro-China, and also it's undermining public confidence in Taiwan's international allies. That is most prominently the US. Also, research found that these disinformation or propaganda exist in more pro-China or the pro-China party, the KMT party's Facebook groups, suggesting a convergence of interest with possible local collaborators. So Taiwan presents an interesting case so militant democracy tells us that there will be threats from within the polity itself. Taiwan's case is more of a mix. So there are prominent threats from the outside, but there are local collaborators too. And also from the traditional media field, we see that this is a case of a Taiwanese business person. He owns a really big food enterprise in China. This is the Wang China company. And then he later bought media companies in Taiwan, and he now owns 3 major outlets: China Times, that's a newspaper, and CTV, that's a television outlet, and also CTI TV. So this is an example. And then there were empirical research that show that the Chinese government has control over the editorial board of the 3 outlets. So this is an example of showing that China is not only trying to influence public opinion online, but also offline. And so this is me setting the table of the threats that Taiwan is facing now. But coming back to the concept of militant democracy that's often cited in Taiwan and elsewhere today, I argue that it's done its job since the Second World War in highlighting the vulnerability of democracy and to highlight the need to protect democracy. It, however, has a lot of limitations. It does not tell us how a protection for democracy can be done, and it does not tell us how to strike a balance between protecting democracy and the other interests that's involved. So this paper is to point out that limitation and to argue that we should come back to a more nuanced understanding of national security, and then to return to the proportionality principle, or what I call constitutional normalcy, or the normal principle of constitutional review. So the second part of the paper, I sort of sift through the concept of militant democracy. And a lot of the debate in the past has been focusing on the purpose of the concept itself, and also on the core question of what is democracy. And on the means of militant democracy, scholars argue whether this is a limitation or an exclusion of rights in the political arena. And also scholars argue what qualifies for that timing we can use militant democracy measure. And this part, I sift through the concept, and first I start with, so what is the purpose of militant democracy, and relatedly, what is democracy, and why is it worth protecting? So there are many theories on democracy, and in their book, Ginsburg and Hawke came up with a minimalist version of liberal constitutional democracy. And there are 3 elements: free and fair election, liberal rights of speech and association, and the rule of law. I argue, building off on their theory, that democracy, there is something more substantive to democracy that is just more than those formal rules, that is more centered on the voting process itself. I argue that democracy is for protecting rights and freedom of individuals, and more so that it's not only the written democratic rules that matters, it's also the unwritten democratic rules and the commitment to safeguarding individual freedom and rights. By unwritten democratic norms, I'm citing Lars Vinks and Levitsky and Zivlot. That includes democratic social contract and also mutual toleration and institutional forbearance. That is to recognize as a political candidate to recognize your opponents as equally legitimate as you are, and to recognize that they have their chance of ruling in the future, and also to have self-restraint and not to abuse your constitutional power. So these, I argue that these constitutional norms and more substantive concept of democracy that includes the protection of individual rights should be the whole picture of democracy. And this is just a supplement. So Kim-Ling Shapil argues that this concept of autocratic liberalism, so this is in the context of current day democratic backsliding. And she found that the liberal democratic constitutionalism concept has been largely ignored. And as authoritarian actors act, they will cite their legitimacy, their democratic legitimacy, and they will use constitutional legal means, but promoting illiberal goals. So I think returning to a focus on the liberal elements of liberal democratic constitution is important. And then another central debate in the concept of militant democracy is when we should deploy this concept. And I think in the past, militant democracy had been seen as a concept that's only used in very extreme circumstances. So only when democracy is facing that existential threat. So I see a parallel in the scholarship of discussing an emergency and a state of exception. And in those scholarship, it asks two questions. So what count as that exceptional situation? And also, what are the permissible measures against such extreme actors? There are two ways to look at it. There are the monistic model and also the dualistic model. So for the monistic model, one can argue that, one can argue that the same normative order should apply across all time and space. And the dualistic model, in contrast, argue that emergency situation will trigger the switch between two orders. That's the normal situation and the emergency situation. And the dualistic model actually builds on the presumption that emergency have a clear beginning and an end. However, I argue that in observing new forms of conflict, that is what we're facing today, like hybrid warfare that is attacking democratic vulnerabilities on all fronts, and also information warfare, like I just shared about, that with the aid of new technologies, disinformation and propaganda campaigns permeate cross-border. So these conflicts become less explosive and less instantly destructive, but have become intertwined in everyday life. They have become mundane and incremental and pervasive. So what I'm arguing is the challenges today are no longer, no longer have a clear beginning and end. So the dualistic model no longer make that much sense. So in the past, we kind of see militant democracy as a one-off doomsday scenario. But because of the new challenges we face today, I argue we should come back to the normative framework that guards democracy against day-to-day challenges. So the second part of the paper points out that militant democracy have served as a valuable concept post-Second World War. However, it has a lot of limitations. It does not tell us how we address contemporary challenges. And I argue that the real work lies in finding measures that are legitimate, suitable, necessary, and proportionate in the everyday scenario. That is returning to the proportionality principle. And because a lot of my work is focused on disinformation and propaganda, I look at the emerging discussion on militant democracy in the US, and they're mostly used in the context of reconsidering the First Amendment doctrines in social media governance. And there was a case that came out last year, TikTok versus Garland in the US Supreme Court. I found that it doesn't cite democratic self-defense or militant democracy, but it has a renewed concept of national security, and also it examines evidence rigorously. It upheld the TikTok law that was passed by Congress. And its centrality is based on finding that China has carried out protracted digital surveillance acts against US personnel. So that constitute a national security threat. And then it said that strict scrutiny was not required, but intermediate scrutiny will be enough, and therefore the law was substantiated. I see TikTok versus Garland as an example to balance national security threat against free speech, even without citing the concept of militant democracy. And the takeaway for me is to argue to come back to the proper understanding of national security that includes challenges in the digital age, like we see in the TikTok case, and also to come back to normal constitutional review principles. And so this is also a part of the chapter that discusses an updated understanding of national security. In the past, national security is more deployed in the scenario where there is a physical warfare. So it's more related to defense or military affairs. Post-World War, it's extended into other non-human threats like global warming or cybersecurity. And some scholars still argue for a more narrow concept of national security, but like I was presenting, I argue that disinformation and propaganda should be included in the matter of national security because it's part of the hybrid warfare. And this research on the last part, in Taiwan, a very recent research shows that pro-China media manipulation in Taiwan does have effect of changing or creating the preferences for neutral voters or pro-China voters. So I propose a more nuanced understanding of national security, plus coming back to the proportionality principle, that is to view the legitimate purpose of such regulation and to do the subsequent steps of suitability, necessity, and proportionality as such. So I know my time is coming to an end, but so in Taiwan, we do have a more US-German fusion of categorical proportionality principle. And because in its earlier constitutional court case, protecting the liberal democratic constitutional order has been recognized as a legitimate purpose. It is not only a legitimate purpose, but a limitation to its constitutional amendments. So it's like the core value, liberal democratic constitutional order is like the core value in the Taiwanese constitutionalism. And I argue that government should present evidence rigorously in this context and to present to the public what effects or harms of disinformation or propaganda is causing to Taiwan. And just as a last bit of information, just in January last year, the Ministry of Interior in Taiwan filed to its constitutional court to dissolve a Chinese Unification Promotion Party in Taiwan. And they're citing evidence of its core member violating a lot of national security laws as the justification for dissolving this party. The court has yet to consider this case, but I think this will be a very good test case for Taiwan in terms of national security and militant democracy and proportionality principle. All right, thank you so much.
Thank you, Wei-Yan. Our second speaker is Rogério Rodoni, who is going to talk to us about the constitutional dimension of the Court of Justice of the European Union and the European Court of Human Rights, jurisprudential trends on guarantee of a pre-established judge. Rogério, the floor is yours. Your sound is muted, Rogério.
Okay, now it should be okay. Okay. First of all, I would like to thank the organizer for the opportunity to be here today and for making this event possible. I'm truly grateful for being part of it. In my presentation, I will address only the main points of the paper which I presented, dealing with the jurisprudential trends on the guarantee of the tribunal established by law, and their constitutional implications on the national judicial systems. In this perspective, in the last minutes, hopefully, of my presentation, I will make some brief references to the implication of those trends on the Italian system. In recent years, it is well known that the guarantee of the tribunal established by law has been acquiring prominence in the jurisprudence of the European courts. The case law reveals a convergence in a functional interpretation of this guarantee. Both courts have gradually broadened the meaning of establishment, interpreting it not merely as a requirement concerning the legal creation of courts, but extending it to the appointment of judges, to internal organization of courts, and the objective and predictable allocation of cases. In both systems, procedural safeguards ensuring the enforceability of the guarantee are deemed inseparable from the substantive core of the same guarantee. In this sense, the right to be judged by a court established by law requires the existence of accessible remedies, enabling parties to challenge violations of rules or situation, undermining the independence and impartiality of courts, even in appearance. It is worth noting that this supranational evolution links the guarantee of the tribunal established by law with broader rule of law requirements. The certainty in judicial organization serves as a systemic purpose, which is preserving public trust in the administration of justice. Consequently, the requirement of a pre-established judge has implications that reach beyond individual cases and touch upon the very architecture of national judicial system. Starting with the perspective of the European Court of Human Rights, here the guarantee, which is enshrined in Article 6 as part of the right to a fair trial, has consistently been interpreted through a pragmatic and teleological lens, both in relation to the concept of law, encompassing any domestic provision, legislative or otherwise, and the notion of establishment. Establishment refers to rules governing the creation of judicial offices and also to the composition of adjudicating bodies, and also as a third dimension to the proper appointment of judges. This evolution aims to prevent undue interference in the administration of justice at all stages, from the appointment of judges to the assignment of individual cases. A landmark moment in this jurisprudential development, of course, which cannot be here deepened more, has been the Grand Chamber's judgment, Gudmundur Andri Andrason versus Iceland of 2020, which established a three-stage test for assessing this kind of a violation. The test requires the evaluation of the existence of a manifest breach of domestic law, the seriousness of this breach, and the effectiveness of national judicial review mechanism. This third stage has emerged as the most systemically significant, since the European Court of Human Rights subjects national decisions to a strict review, requiring national courts to apply its substantive criteria and to provide a reasoned decision. In multiple cases, the European Court of Human Rights has found violations because the domestic courts failed to examine the substance of the alleged breach or relied on purely formal arguments. As to the approach of the Court of Justice of the European Union, it starts from a dual perspective, because the guarantee of the tribunal established by law is found basis both in Article 47, paragraph 2 of the Charter of Fundamental Rights, and also Article 19 of the Treaty on the European Union. This dual legal basis broadens the scope of the guarantee beyond the traditional fair trial context to encompass any national court responsible for the interpretation or application of EU law. Like the European Court of Human Rights, the Court of Justice has interpreted the pre-establishment in a broad functional manner to prevent violation on the feature of institutional feature of independence and impartiality. The decisive criterion is whether the alleged irregularity in the case assignment, in the establishment, or in the appointment of justice is capable of compromising judicial independence or impartiality. This approach was articulated in the 2020 judgment Simpson, in which the Court of Justice examined irregularities in the appointment of judges of EU Civil Service Tribunal. The Court of Justice has applied the same framework in several preliminary rulings concerning national system, in this way emphasizing that member states retain discretion in organizing their judiciaries, but must exercise that discretion consistently with EU values, and between these kind of values, of course, the rule of law requirements, and of course, the effectivity of judicial remedies. A distinctive feature of EU law jurisprudence concerns the procedural obligations that follow from the guarantee. The Court of Justice has classified issues related to the pre-establishment as matters of public policy, requiring national courts to raise them ex officio. Furthermore, because the relation to Article 19 of the Treaty of European Union, and also to the Article 47 of the Charter itself, because these kind of provisions have direct effect, national courts must set aside domestic provisions that prevent them from ensuring effective judicial review of an alleged breach of the guarantee. And this can entail disapplying national rules that restrict access to remedies, to procedural remedies, or that prevent scrutiny on irregularities affecting judicial independence and impartiality. So both the case law of the European Court of Human Rights and the case law of the European Union Court of Justice have strong implication, constitutional implication in the organization of national judicial system, and also in relation to the procedural remedies related to violation of the guarantee. This is well expressed by the Italian case. Italian procedural frameworks provide only limited avenues to challenge irregularities in case assignment. Neither criminal nor civil procedure provides remedies expressly designed to challenge a violation of the rules governing case assignment or the composition of judicial panels. Attempts by domestic jurisprudence to circumvent this limitation have produced inconsistent and often excessively restrictive outcomes. These approaches do not align with the supranational criterion, which focuses on the potential impact of this kind of irregularities on independence and impartiality. Such a situation shall be overcome, of course, and in this sense, there are several corrective options. The best option is, of course, an intervention by the legislature, but this kind of intervention is not predictable, and of course is not cannot predict it as soon. So in this situation, national bodies are in charge of overcoming this lack of procedural remedies. A first remedy is the issuance of a question of constitutional legitimacy regarding provision that preclude nullity or other procedural remedies. In this case, the internal procedural provisions can be challenged before the Italian Constitutional Court because they are deemed to violate constitutional right to defense and to fair trial, enshrined in Italian Constitution at Article 24 and 111, as well as the guarantees set out in International Convention, Article 6 of the European Convention on Human Rights, and European EU law, so Article 19 of the treaty and Article 47 of the Charter. Alternatively, in line with the Court of Justice view, the domestic court could directly disapply national provision that conflict with primary EU law, endowed with the direct effect, where such provisions are deemed to preclude a finding of nullity and thereby undermining the effectiveness of judicial protection and the fairness of the proceedings. This conclusion appears consistent with the meaning attributed to the relevant guarantee by the Court of Justice. The solutions outlined, the domestic one and the one which relates to EU law, are necessary due to the lack of other remedies available under the current legislative framework. As I said before, legislative reform may ultimately be necessary to bring Italian procedural law into alignment with European standards, striking a balance between the need for effective guarantees and an efficient administration of justice. Meanwhile, ongoing tensions appear to force judges to undertake the challenging task of applying procedural rules in accordance with the guarantee of a court established by law, potentially making use of the coordination tools, interpretative and procedural, between the different levels of the integrated European system for the protection of fundamental rights, the national level and EU or conventional level. Thank you very much for the opportunity and for the attention.
Thank you, Rogero. Our next speaker is Paulina Jabłonska, whose presentation will be on abortion rights overhyping. Paulina, the floor is yours.
Thank you very much. I have a problem with, I try to share my slides.
We'll give you a few seconds.
Mm-hmm.
Your sound is muted, but we can see your presentation now. Paulina, your sound is muted. You need to unmute your mic.
Yeah, I will try again. And now
Yes.
my slides are visible.
Good.
Yeah, perfect. Sorry for this technical problem, and thank you very much for having me. Today, I want to share with you my perspective on constitutional abortion rights and the argument I'm working on. And basically, I have three claims. First, that I mean both academics and non-academics, tend to portray abortion rights as more vital in women's lives than they truly are. Second, that I'm afraid that there is little evidence that the constitutional right to abortion or access to abortion itself can make our constitutional order better. In fact, to make people's lives better, meaning less painful, we should shift the focus from women's rights to women's harms and other social costs we bear due to current abortion landscape. And before I will move to the first part of my presentation, let me start with two important caveats. First, I'm not against abortion rights as such. What I criticize is centering the discourse on rights. But to be clear, I don't want to suggest that we shouldn't discuss abortion rights and women's rights at all, nor we should discuss women's harms instead of women's rights and abortion rights. Rather, in my view, it is a question about the order or line in our argumentation and discussion. And because my fear is that if our starting point continues to be discussing abortion rights, nothing or little will probably change for the better. So that's why what I want to say, to argue, is that we should start by answering what harms women suffer today due to current abortion laws and what costs we bear as a society due to their suffering. And only then we can start discussing law reforms, including constitutional reforms. The second important caveat is that I'm still in early stages, so critical comments and any recommendations and suggestions are highly appreciated. And I will share my thoughts in three basic steps. In the first part of my presentation, I will focus on what is the problem, or more precisely, how I think about the problem. In the second part of my presentation, I will try to answer the question, why am I skeptical about constitutional abortion rights or treating constitutional abortion rights as a solution? And in the last part of my presentation, I will focus on the question, why do I propose focusing on harms in, at least now, in this discussion. So moving on to the first part of my presentation, our starting point is legal scholarly debates over abortion. And my observation is that this discourse, these debates, still center on rights. Many works suggest that current abortion laws violate women's rights. Some argue that abortion rights or access to abortion should be recognized in law, particularly in constitutional law. And in this regard, it is not surprising that ideas for constitutional reforms have emerged. This is particularly the case in Europe, where in 2024, France became the first country to enshrine the right to abortion in its constitutional regulation. Also in 2024, the European Parliament of the European Union urged member states to amend the EU Charter of Fundamental Rights to include reproductive rights, and particularly including the right to abortion, to safe abortion in the Charter. So against this backdrop, the question is, what is the problem? Or, as I said before, how I think about the problem. And in my view, to understand the problem, we should consider a woman who decided to terminate her pregnancy, but was denied safe access to abortion in her home country. Or imagine a rape survivor who was denied pregnancy termination because of conscientious objection. Or think about women who have never been pregnant, but have heard about other struggles with abortion law. My question is, or the question I want to pose is, what harms all these women suffer? And what social cost do we bear due to their suffering? And my point is that this still remains unclear, at least in context of our legal scholarly debates over abortion. But this brings me to the question, are constitutional abortion rights or constitutionalization of right to abortion is really a suitable response to these issues? And my general point is that I'm skeptical about constitutional abortion, constitutionalization in this context. What brings me to the next part of my presentation, in which I will try answer the question, why am I skeptical? In short, I don't believe that constitutionalization itself can make our constitutional order better and our particularly everyday life better. And there are a few reasons. The first, on more abstract maybe and also theoretical level, there is a vast body of literature in constitutional, comparative constitutional scholarship focusing on the relationship between rights, particularly constitutional rights, and socio-political outcomes. And as Adam Chilton and his colleagues clearly write, empirical research suggests that there is typically not a positive correlation between countries constitutionalizing a right and those countries actually respecting it. So we have to keep in mind in the debate about over abortion and constitutionalization that on the one hand, we have normative level, what we enshrine in our constitution. But the other thing is what's going on in constitutional reality. The second thing is that even if we want to stay at normative level, we have to keep in mind that the vast majority of constitutional rights can be limited. So even having constitutional, having the right to abortion or access to abortion in our constitutional regulation doesn't mean that lawmaker or legislator cannot restrict access to abortion in the statutory law. And the third point, and the third thing, which also have to be considered, is that even liberal abortion legislation is not enough. It doesn't guarantee access to safe abortion in reality. And this is the case in Italy, where the problem doesn't lie in restrictive abortion legislation, as they have quite liberal regulation when it comes to statutory law, but they have a problem in practice in regards to conscientious objection and the scale conscientious objections are employed. So taken together, I'm skeptical about constitutional abortion rights as a kind of solution to women's to violations we as lawyers and constitutional scholars see in constitutional reality, because I think that it is just not enough, it is not sufficient to make our constitutional order better and make it in our everyday life better. So now, the final part of my presentation is why do I propose focusing on harms? Because the one thing is whether constitutional reform, I mean constitutionalization of right to abortion, is sufficient. And that is what I have focused on in the second part of my presentation. But the other thing, and which is also very important in this context, is whether this reform is possible, is reachable, is achievable in our socio-political reality. And I'm afraid that in many jurisdictions, this reform is hardly achievable, because we also have to keep in mind that there is still deep polarization in societies when it comes to abortion rights. And this is especially evident in Poland, in my home country, because on the one hand, we have in mind in abortion discourse, legal scholarly debates over discourse, pictures from Poland. I mean, large protests in hundreds Polish cities during COVID-19 pandemic in defense of women's rights, after the Polish Constitutional Tribunal in 2020 decided that abortion on embryopathological grounds is unconstitutional. But on the other hand, scholars have also observed anti-abortion mobilization in Poland. And research describes how right-wing actors mobilize to restrict access to abortion and punish women for abortion by subsequent legislative initiatives, public campaigns, and litigation against abortion activists. So the idea is that since abortion rights provoke disagreements and polarize societies, we should refocus on the room where the agreement is reachable. And the point is that focusing on harms women suffer due to current abortion landscape and social costs we all bear due to this suffering might be such a room. And I think that we have evidence, and I have in mind the case of Ireland, because for many years, Ireland was one of the most restrictive jurisdictions regarding abortion regulation with constitutional abortion ban. But in 2018, Irish people decided in referendum to remove this ban from their constitutional regulation. And what is particularly interesting to me in the whole context is what Fiona de Landras clearly wrote in her piece, that people voted for repeal of the 8th Amendment fundamentally because they thought it did harm to women who should be trusted to make decisions about their own reproductive lives. And human rights law had little, if anything, to do with it. So in this context, I think that this perfectly shows that harms and costs we all feel and see may matter much more than rights in when we discuss, when we try to change constitutional reality and change and make our constitutional order better. So that's it. Thank you very much. And I will be glad to hear all your thoughts and comments.
Thank you, Paulina. And now we have Sheng Hongzi, who will share with us his thoughts on constitutional interpretation in Malaysia between judicial Islamization and pluralist constitutionalism. Floor is yours.
Thank you very much, Professor Gonzalo, and thanks so much, Professor Maris, and also fellow panelists. Could you see my screen? Let me just share this one. Yeah. Yeah. Is it visible to everyone?
It's visible. Yeah.
Thank you very much. Yeah. So today I'm talking about a constitutional interpretation in Malaysia between judicial Islamization and pluralist constitutionalism. Because it's a work in progress, I'll focus on the first part, which is the judicial Islamization. And so this will be the roadmap of my presentation. First of all, I will set up the context of why it matters, why this problem is very important in Malaysia. And second, I will say that I will give my hypothesis that judicial Islamization is a conceptual conflation between Islamic law that was state-imposed and between the Sharia within the wider notion of Sharia within the Islam, within the religion of Islam. And third, I will suggest how to constrain judicial Islamization through a conceptual analysis of Islamicate. And first, I show this picture. So this happened in November 2023. So this was at the peak of the hearing of the case of Nick Allen, where the court was deciding the constitutionality of the state Sharia enactments in Malaysia. And in that case, the court struck down 16 Sharia offenses. that includes the criminalization of sodomy, gambling, and etc. So those offenses were, according to the court, was unconstitutional and void because they belong to the federal jurisdiction and not belong to the state jurisdiction. And that creates a huge repercussion in Malaysia because the public role of Islam remains the largest fault line between socially, legally, and politically. So that's why it is a huge contestation within the society, not only within the social political norms, but also within the judiciary. There's as we will see, there's a shifting constitutional interpretation regarding what is meant by Islam and Islamic law, which has a lot abundant notions within the federal constitution. So that means that in recent years, the rise of political Islam, as we can see, thousands of people protesting before the federal court in this case, when the case was heard, it shows that how hugely contested and how much implications that this kind of this constitutional interpretation could generate, the controversies that can generate, and also not least because of the legal implications. Because in Malaysia, one's religious status is not a personal matter. It is a constitutional matter because according to the Constitution, Article 160, subsection 2, a Malay is defined as someone who professes the religion of Islam, so someone who is a Muslim, and someone who speaks the Malay language, and someone who is professes the Malay's custom. So if someone is born a Malay Muslim, they are subject to a separate law, which is the Sharia law, and Sharia law falls within a state jurisdiction. So this explains a very hugely complicated and complex nature of the constitutional jurisprudence and also the constitutional context of Malaysia, which leads to my question. So my hypothesis is that the Malaysian constitution notions of Islam, Islamic law, and Sharia courts do not correspond exactly to the wider notion of Sharia in Islam. And I argue that according and echo what Professor Salame in 2021 posits, that the equation of Sharia with Islamic law is actually a result of coloniality in secular translations of Islamic law. In other words, Islam itself has its own doctrines and jurisprudence, but it cannot be comport with what we understand as law and religion in a secular context. And because of colonization, it transfers it, or it translates wrongly, it transplants wrongly those ideas. So it reformulated Sharia in its own reasoning, and that happens especially. Malaysia serves as a perfect case example because Malaysia was previously colonized by the British, and they are the one that actually started the project of formulating the Islamic law. And this project actually got continued even within after the post-colonization period. But here, I'm not problematizing. I'm not making problematic the coloniality per se, but I'm saying that we need to discern the colonial origins of the Islamic law in Malaysia so that we can distinguish between what is meant by Islamic law in the constitution and what is meant by Sharia in Islam. And what makes it more exacerbate this confusion, this conceptual confusion, is in 1976, there's a constitutional amendment in Malaysia where it transforms, it changes the term of Muslim law to Islamic law and Muslim courts to Sharia courts. And that again makes this confusion even more easy to or more harder for the judges to resist them. So it's easier for the judges to confuse both Islamic law and Sharia because of this constitutional amendment. So my hypothesis is that this conceptual conflation of Sharia and the state-imposed Islamic law is actually the driver of judicial Islamization in Malaysia. And I should explain also more what judicial Islamization means in Malaysia. But basically, in short, it means that the prioritization of Islamic norms, but I argue they are not actually Islamic norms, but they're actually Islamic norms, which I have explained in a bit. And that the prioritization of these norms over the constitutional norms in Malaysia. And one example is the 2009 case of Sulaiman Takrib. So, and apologize that I didn't include this case in the position paper, because this was a work in progress, and I only recently discovered this case. And the 2009 Sulaiman Takrib case, you can see a part of this paragraph says that the word Islam in the federal constitution, Islamic law, the word, if it translates to Malay, it means hukum syarak. And in that way, it actually equals to Sharia, because Sharia is actually a very similar word with Sharia. So, and even more so, the court says that the word in the precepts of Islam in the constitution includes both law and Sharia. So in some way, the court is actually conflating a lot of different, hugely loaded notions, law, Islamic law, Sharia, as one thing, as the same thing. And most importantly, even more obviously, the court said that according to Islamic jurisprudence, which is not the jurisprudence like what we understand as a constitutional law, but the jurisprudence within Islam, there's a difference between Sharia and fiqh. So Sharia is, if I may, to define, it is not just law. It's a body of rules, ethics that governs the Muslim life. So it's like a conduct that teach Muslim how to behave, what a certain code of conduct. Is broader than what just law. But fiqh is actually a human understanding of what it means by Sharia. So a human understanding, a juristic understanding of what Sharia means. So Sharia itself is, in Islamic jurisprudence, is considered infallible or something like a divine revelation. But fiqh is definitely fallible because there's a human understanding. So it's necessarily imperfect, and it has to adjust to the contemporary standards. But interestingly, in this context, in this case, the court say that no. If you look at, there's a word Sharia courts in the federal constitution, it covers both Sharia and fiqh. So the court not even trying to pretend that there's a difference between both of them. The court said no, because what we have the Sharia court, the word in the Malaysian constitution, so we have to treat them the same. We don't care about whether there's an Islamic jurisprudence, they're different. We just follow what the federal constitution says, and they conflate both of them. And the court even further explains that the Sharia law in Malaysia not only includes fiqh from the Islamic jurisprudence, but it's a hybrid because it also contains provisions from the English common law. As we can see, the Civil Procedure Code, we can see the civil codes, and also other provisions from the civil courts. So in short, it is a hybrid. However, things has changed in 2024. So in the case, we return to the case of Nick Allen. So in that case, 16 Sharia enactments were struck down, and the court, in a very surprising manner, in an 8-1 majority, held that Islamic law is not the basic law of the country, because the secular-leaning constitution is the ultimate source of law due to constitutional supremacy. And the constitution declares itself supreme in Article 4, subsection 1. And the court even said that even if it is a purely religious offense, the legality and constitutionality of each state Sharia law should and can only be determined by the civil courts, notwithstanding Article 121(1)(a). So Article 112(1)(a) basically says that the civil courts shall not have any jurisdiction in matters belongs to within the jurisdiction of the Sharia courts. So this is like a precaution clause. Further, the court even said that Article 3, subsection 1, Islam as the religion of the Federation clause, should be read together with the non-derogation clause of Article 3, subsection 4. So what it means is like it limits the extent or the meaning of constitutional meaning and significance of Islam as the religion of the Federation clause, because Article 3.4 says that this provision, Article 3, should not derogate from any other provisions in the Constitution. That means that it's a self-limiting declaratory clause. But I think there's certain problems with so Nick Allen it has shifted away from the 2009 Sulaiman Takrib case, because in that case the court was not willing to strike down the Sharia enactments because they said that the Sharia enactments were basically Sharia, so they are Islamic law, and it does not it does not fall within the jurisdiction of that civil courts to strike it down. And the court conflate those notions between law, Sharia, and Sharia courts. But Nick Allen tried to distinguish them. However, I argue that Nick Allen could be further buttressed because of using an Islamic case analysis. So what do I mean by Islamic case? So there's a distinguish between Islamic and Islamic case. So Islamic case is actually a notion coined by Marshall Hodgson to refer to elements not directly related to Islam, but to the social culture complex historically associated with Islam. For example, Arabic is an Islamic case language. Even if it is a language that used to transcribe Quran, but it is not Islamic language because it's just historically associated with Islam. So according to Salameh, any given Islamic system in any given historical, social, cultural, and geographical context is necessary an Islamic legal syncretism. Echoing that, I argue that the Islamic legal system in Malaysia is in fact an Islamic legal syncretism, because like just now, even Sulaiman Taqrib confirmed that it is a hybridity between English common law and also the Sharia, the so-called Sharia law in Malaysia. For example, the Sharia is translated as Islamic law. The Sharia courts itself is a hybrid between both the Sharia and the courts that derive its origin from the English common law doctrine. And jurisprudence, the word jurisprudence is equated to fiqh, and Qadi is the Muslim judges is equivalent to like Sharia court judges. So a lot of these terms, so even if they use the so-called Islamic or Sharia terms in the constitution, I argue that the logic and the reasoning behind them is still fundamentally an English common law one. So the significance of us using this Islamic case analysis is to first avoid the conceptual conflation of Islamic law and Sharia, like what we say. Second, to counter the ahistorical constitutional narratives. So in short, there was a prevailing constitutional narrative in Malaysia saying that Malaysia before the colonization of British is a truly Islamic legal system. But using Islamic case, we can understand that it is an Islamic case because it's a hybrid. Before the colonization, there's a strong Hindu-Buddhist influence. So second, but third, which is what I really want to focus in this presentation, is to refocus what makes Islamic law rather than what makes it Islamic. And that is what I argue that Nick Allen has started, and the Islamic case analysis could further buttress it. So in Nick Allen, paragraph 87, it says that the general legal system in Malaysia leans more towards secularity without being purely secular. But at the same time, the court also says that Malaysia has a dual legal system, a secular and Islamic law legal system. However, the court does not say Islamic legal system. The court said Islamic law. And I argue that that law itself is very important, because using discerning the Islamic nature, we can understand that there is a conceptual clarity to treating Sharia law as law, rather than treating them as a divine provisions. And second, it gives them power legitimacy to strike them down. For example, in Nick Allen, when the state Sharia law encroaches on federal jurisdiction. And third, to avoid the judges having some subjective judgment of what is and what should be Islam and influence their judicial interpretation. So to conclude, there are various factors that shapes the Islamic law in Malaysia: political, social, legal, institutional, and some part of it also derived from its colonial origins. And also at the same time, we have to look at the contemporary political context as well, because as we can see in the first slide, there is a huge trend, a strong religious community that endorse a certain interpretation of Islam and hope that the constitutional court can authenticate those kind of interpretation. And what more is particularly problematic is the state imposed, the state trying to rigidify a certain conception of Islam through codification, through changing of the terms in the 1976 Constitutional Amendment. Notwithstanding that, Nick Allen in 2024 managed to constrain this so-called judicial Islamization that we see in Sulaiman Taqrib. But inevitably, this question is about the role of judges. How far should judges determine this, what means by Islam, and how should they move the focus away from Islamic to the law. And the role of Tengku Maimun, the first female Chief Justice in Malaysia, is very crucial. And also the judicial unanimity, as we can see in various cases, is very important. But finally, I want to finish with this conclusion. A conceptual analysis using this Islamic as a metonym is enriched, it pluralizes, it assists the judicial understanding of its history of Islam, Islamic law, and Islamic legal institutions in Malaysia, and therefore help us to have a better constitutional interpretation of Islamic law, because it helps us to know that there's pluralism, not only within Islam itself, but also there's different understanding of Islam. So when there's an Islamic law itself, is a hybrid product. So understanding this helps the court to avoid themselves to fall into the epistemic trap of equating Islam equals to Islamic law and equals to Sharia outside of the constitutional context, but allows them to follow what is written in the constitution and uphold the constitutional supremacy in Malaysia. And with that note, I conclude my presentation. Thank you very much.
Thank you, Sheng. The four of you were admirably disciplined. You did not exceed, at least significantly, your allotted time, making my life as a chair very easy indeed. And now it's time to give the floor to our distinguished discussant, Professor Maris Amos, who will make comments for about 20 to 25 minutes. Maris, thank you again. The floor is all yours.
Yes, thank you very much. Thank you, everybody. It was very interesting. I know Wei Ann has left, hasn't she? She said she would watch the video. So just for her benefit, just a few comments about her paper. I do very much agree with her that the concept of militant democracy is of very limited practical use in the context she was referring to, and possibly very dangerous, because who's going to decide what is constitutional identity of a state, and who's going to decide who or what is an anti-constitutional force? I did have an issue with her definition of democracy. I don't know if you recall, she said it was something that a form of government that best serves to protect individual freedom. I thought that was a very strange definition of democracy, because you can protect individual freedom in other ways. So perhaps with the Bill of Rights or protection of human rights, and democracy is more about power from the people and representative democracy. And then the final point I wanted to make is she was making the case for just utilizing simply constitutionalism, really going back to proportional analysis, review, and grace of proportionality restrictions. I'm not sure why focus so much on national security when you can do this with the human rights framework. You can look at it from a freedom of expression, restrictions on freedom of expression, or you can look at this as, in the European context, Article 3, Protocol 1. So there's been a really interesting case from the European Court called Bradshaw in the United Kingdom about obligations on states to protect the electorate from hostile interference. And so this was hostile interference from Russia in the context of the Brexit referendum. And they found they developed the principle really interesting, didn't have to worry about national security. It was more about protecting the democratic process. But they found there was no breach on the part of the UK. So moving on to the people that are here, Ruggero from Italy. This is a really interesting point, and I know Italy has a number of challenges with Article 6 in European Court of Human Rights. And I know that some of the measures that it's put in place to address that have also been found to be incompatible with Article 6. So just a few things I wanted to understand in a little bit more detail about what you meant by case assignment rules, because you summarized a lot of law in a lot of detail, but from your written paper and from your presentation, I think you wanted to talk about case assignment rules. And I'm not sure if you're allowed to, are people allowed to answer back? Is if you wanted to tell me what you meant exactly by case assignment rules, because maybe I was misunderstanding.
Yeah, of course. With the case assignment rules, I mean the rules for the internal organization of judicial offices. So the rules that govern, for example, the power, the discretion of the president of a section of a criminal section of a tribunal, of a civil section, to assign a specific proceedings to a specific judge.
Right.
On this point,
that's what I thought. That's what I thought. So then I wasn't really, I wanted to understand the nature of the problem a little more. So is there assigning things to judges that are not qualified, or are perhaps questions over independence and impartiality? I thought some examples would have been really useful there. And it would have helped understand that.
If I may answer, I don't know if I can answer.
Sure, you can
of
answer.
course.
I think it's good if you do answer, yeah.
Okay, perfect. And the point is that, of course, the limit of words and as to the paper, the limit of time of my presentation didn't allow me to go in further details, of course. But thanks for your question. An example is there may be two different kind of example. One example is a rule, for example, which give too much discretion to the president of a section, to the president of tribunal in assigning the case to a specific judge. In this way, this is not coherent with the framework of Italian legislature, and also as to the constitutional and EU and conventional guarantees, because from this constitutional EU and European Convention Human Rights framework arises that there shall be objective rules for assigning case in order to avoid the lack of an appearance of impartiality. Of course, the point is not that a certain case may be assigned to a judge which is not qualified or which is in relation to a specific one of the parties. The point is that if the criteria are not objective, this in itself arise a question of lack of appearance.
It's not transparent.
If I may step in, since I was a judge for nearly 10 years.
Yes, absolutely.
The principle of an established judge or natural judge essentially dictates that the assignment or the distribution of a case should not be based on the discretion of any official, but should be randomized. So if a case enters the Court of Appeals of Lisbon, the 3 judges on the panel to decide this case should be decided either by an algorithm or by some other method that is random, as opposed to this being a power, say, of the president of the court, and of course, the power of any other non-judicial actor. So that's the idea, that it should be random. And this is
there's no.
Yes, and the idea is that
this would be a good one for you, or
and it's both an individual right, it's an aspect of a right to a fair trial, and at the same time, it's expected to be a contribution for the trustworthiness of the justice system. So I think, Rogerio, you go ahead and
yeah, thank you very much. Of course, this is one point. So the existence of objective rules in Italy, each judicial office may provide rules for the case under the supervision of with the authorization of the Superior Council on judiciary. So the point is not the primary rules applying, which probably all these kind of rules, the regular rules are the general rules are objective, based on objective criteria. The point is related to the exception. So when you cannot follow the general rule, but when there is an exception, this is one critical point. Another critical point is that I made this. This is part of my research after the PhD. In certain judicial offices, it is followed in criminal cases, criminal proceedings. It is followed another criterion which is not, according to me, coherent with the guarantee. This criterion relies on the fact that the choice of the judge is based on the person who is in charge of being public prosecutor. So that there's public prosecutor. So the choice of the judge depends on the identity of the person who is one of the two parties of the criminal proceedings. So these institutional links, so not only the possible violation of the objective criteria, but also there's also here a critical point on the adequacy of the rule itself, which relies not on an objective criteria, but not coherent with fair trial guarantee.
Yeah.
So
I
this
totally
is
understand.
Okay.
Yeah, no, I do understand. So I think when you've got constraints of time, maybe a little less on all the history of the evolution of Article 6 and establishment, and focus a lot on the nature of this problem. This is the problem you're going to address, and give some examples. Case I totally understand now. One other question I had was it's not possible to challenge this in the national system? No, there's no fair trial guarantee that would cover this.
No, the point is that the interpretation by the Court of Cassation and also the other tribunals and Court of Appeals in Italy is that the nullity remedy, so the declaration of nullity of the acts adopted by a court which is formed by a judge chosen not in coherence with rules, with this kind of rules, is not a matter of nullity. So since it is not a matter of nullity, it is conceived as an organizational matter, is simply a matter inside of internal organization of judicial offices, not a matter of fundamental rights. This is the main point.
Mm-hmm. And is there a concern about interfering in the way judges organize their work? Is that a concern as well? That there's this, even if they're going to organize it in this way, that's for the judges to determine. And there's sometimes a concern on the part of the executive, we can't interfere with this, or
no, there are not concerns related to a possible intervention of other powers, so the executive in the choice of the judge. The point is just a matter of appearance of impartiality towards the parties, and in criminal proceedings toward the private party, not the public one. So this is the main issue.
Okay, great. Thank you very much. So Paulina, I have a lot of comments here because I know Fiona, and my experience is not so much Ireland, but Northern Ireland. And I don't know if you followed the debate there, which has gone a little bit differently to the Ireland issue. So a few things I obviously come back, and if you want to clarify, I'm not sure about basing everything on making the constitutional order better. I don't know if the whole access to abortion framework is about making the constitutional order better, or that should be an objective. Maybe it's probably more useful to think about making our lives better, not just women, but everybody. A kind of really foundational human rights and very simplistic thing. The second thing is, I think you said early stages, so I take that on board, but I think you've got to, if you make claims that everyone's overplaying the importance of human rights, and you've got to have some very good evidence, not just Fiona said that in an article. And she probably might not have meant it as forcefully as you've presented it. She talks about law, like human rights law didn't have a big impact. And I think she means there was no case, like the big case in European Court didn't produce the result in Ireland that was desired. But I think the framing of the whole issue in terms of the language of human rights helped a lot. And that's where a really interesting example is Northern Ireland. And more recent, and as you know, there was a big case in the Supreme Court in the UK brought by the Northern Ireland Human Rights Commission that was not successful on procedural grounds, but they gave a lot of, they did still discuss the human rights issues, especially Article 3, which was really interesting, and Article 8 of the ECHR. So they essentially framed it as a violation of human rights. And I think from the harm perspective, even framing it as a human rights issue allowed the harm to be spoken about in a really structured way. So the individual women they had in that case were really able to discuss the harm that they had suffered. So even though it's a rights litigation, it didn't eliminate the discussion of harm. You can still totally discuss harm. And so what happened was that the litigation didn't work, just like Ireland. Often courts are finding reasons not to make these decisions, but it really provided the impetus for the political debate which followed, and subsequently the prohibition was dropped. Another concern I have is that even if you focus only on harm, it might result in similarly entrenched positions, because both sides of the debate will see harm differently. You will see it from perspective of those who want access to abortion. They see it as a harm to themselves, to society generally, but then those on the opposing side will see it as harm to the unborn, harm to religious beliefs, harm to morality, harm to society. So I'm not sure focus on harm would make the positions less entrenched. And I know that, support for the Law and Justice Party, it's not just about abortion rights, but it is interesting that what the point you make about that perhaps does it really matter given people still vote for this party? I think I'm going on a bit, so I'll give you a chance. Is there anything you wanted to respond or to clarify?
Yeah, maybe one thing. Thank you very much for all the comments and suggestions. Maybe one thing I should clarify when I said about what makes our constitutional order better. I'm following the theory of developed by Cass Sunstein, how to interpret the Constitution, and this is important that I'm following him in terms of how I think about constitutional law and constitutional reforms. I should have said this, but when it comes to other comments and suggestions, I have to think more. But thank you so much. I'm really grateful.
Thank
Can
you.
I ask a question?
Sure. I had
because
some more, but you carry on.
I have not read the Kassenstein book that you've quoted, Paulina. I am aware of the existence of that book, and it's one of maybe 100 books that I mean to read, but I haven't been able to read yet. So is Kassenstein's idea that a good constitutional order is integrative as opposed to divisive? Is that the point? Because there's a moment in your paper in which you gesture towards that. You said that abortion has proved to be deeply divisive, and entrenching a right to abortion has not made abortion more available for most women. And in fact, it has created a topic of such tremendous contention that it has, to some extent, undermined the integrative function of a constitutional order. Is that at all what you're thinking about or not? Maybe
Yeah, I'm thinking in this way. Yeah,
okay.
But I understand
I want to tell you that this is not an idea of Kassenstein in 2023. There is a German constitutional theorist of the 30s with a bit of a dark past, I have to say. Two German theories who should have been mentioned today are the one I'm going to mention now, and in the case of Wei Yan, Carl Schmitt, because Carl Schmitt is really the inspirer of militant democracy as it is understood in Germany and, say, Turkey, and which makes it very problematic, as Mary has said, because Carl Schmitt's the most brilliant adversary of liberal democracy, certainly a brilliant man, but not a good liberal Democrat. And in your case, it's Rudolf Sment. Rudolf Sment wrote a book called Constitutions and Constitutional Law, in which he says that the main function of a constitution is to integrate diversity through a variety of means, from, say, the symbolic dimension of a head of state to rights as devices through which we reconcile our irreconcilable worldviews, a neutral language that provides facilities to all of us that enable us to have a shared public world in spite of our different religions, that we worship different gods and we have different ethical codes and so on and so forth. So maybe you should explore that. I think that would strengthen your argument, which is very intriguing. And I didn't want to jump in, but your paper I thought was particularly engaging because it's so, it's both intriguing and controversial. And I think there is potential. Your argument is quite promising. But there are two things I should rather say. I didn't quite understand a bit like Mary's. I thought that the sharp contrast between harms and rights is difficult to grasp, because many would say, I'm not a utilitarian, but many would say that one of the primary reasons to either recognize or attribute rights is the avoidance of harms. I mean, some utilitarians would say that's the only respectable reason to grant rights. I mean, that's the famous argument of John Stuart Mill in his essay on liberty. So it's a bit strange to think that we are changing anything fundamentally if we migrate from the discourse of rights to the discourse of harms. And the other aspect is that I appreciate your point, which I've made on several occasions in my classes and lectures, that there doesn't seem to be a strong correlation. You quote that piece by Chilton and Versteeg, a strong correlation between entrenching rights and securing the objects of those rights. So, the examples are Brazil has a very long constitution with a very generous catalog of social rights. It reads almost like a policy program, and yet Brazil is one of the poorest and most unequal countries in the world. Portugal has the longest bill of social rights of any member states of the European Union, and Portugal is relatively poor and quite unequal in that context. But there's an argument to be made that it is perhaps because countries such as Brazil and Portugal are quite poor and quite unequal in their respective contexts, that there was an urgency to entrench those rights, so that entrenching a right becomes urgent in a society when the object of that right is seriously lacking. And so it might be that without entrenched social rights, for example, Brazil and Portugal will be even more unequal and even poorer. And you could say the same thing about abortion, that, abortion might not be a serious fundamental rights issue in a relatively liberal society in which it did not become both politically and in terms of women's affirmation in society a matter of urgency, but it might be the opposite in other contexts. And then I think you should also address the issue of backlash, because, of course, what happened in the United States was that Roe v. Wade is a crucial piece in the history of polarization over constitutional issues in American society in the last few decades. So these are all, I think, relevant pieces of your puzzle. Marys, I'm very sorry, I didn't mean to hijack, but I was
No, that's fine. I think we should leave Paulina alone now, and we've given her a hard time, so we can move on to Zhangxi. So I think this is one where the presentation explained a lot more than the paper. So when I read your paper, I had some questions that you answered. So my first question was you needed to expand on the basic structure doctrine, what it was, why it was needed, how, and when it's used in cases involving Islam, how would it work? What are these cases? Because setting up the problem, and then the question about the personal religious convictions of civil court judges you played down in your presentation until the end, and so I can come back to that in a moment. So yeah, you made a really great start because you explained the Nick Ellen case, and this was huge contestation, the shifting conceptions. Again, maybe a little bit more background would help those of us new to the issue and to the discussion. I thought this was a really interesting examination of how there is these two conceptions, the Islamic law legal system or the Islamic notion, and but at the very end, and you can clarify for me, I got the impression that there was still this issue of judges. They've been presented with a way forward by the Nick Ellen case and by your notion of the Islamicate, but how to address the problem of, is there still a problem of judges backing essentially impartiality on these questions? Or is it now there's a solution, and for a judge who's in a difficult situation, they can utilize this solution to for a way forward? And if it still is about judges and personal religious convictions, that's a really serious point. And so I was wondering just about those guarantees, also that we were talking about with Ruggiero, this notion, well, how are judges appointed? How is their independence and impartiality guaranteed? Can you appeal if there's a real possibility that the tribunal was biased? I had a quick look at the Malaysian constitution, and I couldn't actually find, is there a right to a fair trial in there? There doesn't appear to be a freestanding clause. It's in bits and pieces. So it seemed to me you couldn't actually do any of this stuff constitutionally. So anyway, Zhangxi, you can tell us what.
Thank you so much. I think you asked touched on a very important question. I think that's why I'm dedicating a separate chapter for that regarding the role of judicial institutions. And I have to admit, because I've done a summer internship in the judiciary. So based on the snippets that I got during my internship in the judiciary, it seems to be still a huge problem within the judiciary that there's this kind of independence and biasness. However, I have to say that the reason why we have this shift in Nick Allen compared to previous case is because we have a change in the judiciary in appointment system. So because previously there is a time of conflation between the political inclination of the judge with the government, and the government is pro a more Islamic interpretation, so the judges follow their interpretation. But since 2009, there's a shifting position. So the role of the government executive in appointing the judges has been limited through a statutory instrument, which is the JAC, the establishment of the Judicial Appointments Commission. However, however, similar to UK, it seems that it is by convention, because there's no change in the constitution. It's still up to the prime minister to advise the king to appoint the judges. So, but luckily, since it's at that establishment, and we can see there's a change. It takes time. So I would say the turning point is 2017, 2018, where we have a huge batch of judges, including Tengku Maimun, who was appointed, and she herself is very religious pious, as everyone know. But she said that no, she can separate her personal religious conviction with the separate judge. However, the current government actually did not treat her well. So during her retirement, they allowed a lot of they did not respond. The government allows a lot of people to criticize her publicly in the media, and does not extend so she has, every judges has like a 6 months extension period for them to finish what they on duty. So there were 9 judges retiring at the moment. So all judges will get the extension except her. So the government is sending a signal that she's not a good judge. So
Right. Okay, so
that's
definitely worth another chapter. It's not only the independence, impartiality of the judiciary, there's executive interference, and so their objection is because she's not utilizing a religious element in her decision making.
Yeah,
Wow.
yeah, exactly.
Okay, so
Exactly. Both political and religiously. Because she's very outwardly outspoken. She said no, she won't allow her religious understanding to affect her understanding of. Yeah, so that's why she got
okay, so
attacked.
you've definitely got 2 problems. You've got the problem of a jurisprudential problem. How can we separate the two? How are we going to make this work in practice? And then you've got, well, we can have the best will in the world. We can develop a doctrine, but we've still got judges that are either unable, well, they've got their own religious convictions that they're bringing to their adjudication, or there's a fear that you're going to be punished if you step out of line.
Yes,
Okay.
yes. And
Right.
if I may quickly answer your second question regarding the right to fair trial. So yes, it is not part of the Constitution, not part of it, but we do have it in our procedure code. So there's a Rule 137 of the Supreme Court rules, which allows them to judicial review the final decision of even the federal court if there's huge miscarriage of justice. However, the threshold is very high.
Okay, so there wouldn't be
threshold is very high.
review for just the standard or the
No.
real possibility the tribunal was biased. So
Yes,
that doesn't. So that's also compatible with lots of international guarantees on.
No. But however, there's a very interesting. So we have an automatic right to appeal to Court of Appeal. So if you, for example, the first instance court is High Court. If you fail that, there's an automatic right to appeal to the Court of Appeal. But there's nothing to stop them from, like, even if you stop at Court of Appeal, and if the federal court does not give the leave to appeal, that's the end of the matter. Sometimes the case cannot even reach to the federal court, full hearing at the federal court. So yeah. So there's no freestanding of right to fair trial, and it's just mainly common law and procedure, but not necessarily enshrined in the Constitution per se. Yeah.
I think Goncalo had a question. Did you?
No, I don't.
Okay. I think they're the comments I had. Is there anything anyone would like to ask?
think
No, or-
Hank, go ahead.
yeah, I have a question to ask Florina actually. So I really like your presentation. I think because as you mentioned about how you problematize it as a right, but does it also contingent on how the rights is entrenched in? Because according to various jurisdiction, some countries entrench the rights as, for example, statutory rights. Some is constitutional codified. Some is actually like Roe v. Wade is a constitutional court interpretation. So does the way and manner and the degree of how entrenchability of those rights affect your analysis where you problematize the centrality of rights in abortion cases?
Yeah, thank you so much. You mean I should distinguish by what I mean constitutionalization in terms of form? Yeah, yeah. Thank you so much. I will focus on it. I can say that in my initial understanding and let's say interest, I was focusing on constitutionalization in terms of what is written in our constitution, so constitutional amendment. But yeah, I'm not sure if I maybe I should focus also on judicial interpretations.
Any other questions for panelists?
I also have a question, Maris. Is it like a written feedback or do you just have this feedback just within this panel?
I understood it was just feedback in the panel. Yeah, I do have some notes, but I think I've conveyed all of those to you. So we're down one presenter, so I think we could finish a little early.
Yeah, yeah. So thank you all. I think this was wonderful. Thank you, Rogero, Paulina, Sheng, and Mary's, of course. Good luck for your future research, junior scholars. I think these are promising and very interesting papers. And it was a real pleasure to chair this session. And thank you also to our hosts of the Universidad Autónoma de México, and particularly to Professor Jose María Serna. Thank you so much.
Thank you.
Thank you,
Thank you so
everyone.
much.
Thank you so much, professors.
Bye, Marys. It was good to see you.
Yeah, see you soon. Are you going to Sweden?
I'm probably not going to Sweden, but I'll see you in Bogota. You're going to Bogota to the big conference.
Yeah, I don't think I can go to Sweden either.
Yeah, I don't think, yeah, it's too much. May
No.
and July.
It's too much traveling.
Yeah.
All right. Well, I'll see you
There's a
then.
lot of grading to do in May, at least in Lisbon. I'm sure it's the same thing in London. Do you grade papers and
And it also
exams?
falls on it's falling on a holiday, a bank holiday in the UK, and so I just really can't. And so we can attend online.
I'll see you in Bogota.
Yeah. See you then. Bye.
Interesting place. See you then. Bye.